Hello friends, today in this video we shall discuss limit of managerial remuneration which has been provided in part 2 of schedule 5 of Companies Act 2013. Let's see what are the limits. Part 2 of schedule 5 has 5 sections. First one section 1, remuneration payable by companies having profit. Part 1 deals with remuneration payable by companies. Section 1 deals with remuneration payable by companies having profit. Section 2 deals with remuneration payable by companies having no profit or inadequate profit. Let's see what the section 1 of part 2 of schedule 5 states. Remuneration payable by companies having profit subject to provision of section 197. Subject to provision of section 197, a company having profit in a financial year may pay remuneration to managerial person or persons not exceeding the limit specified in such section. Specified in such section means section 197. So company having profit may pay remuneration not exceeding the limit specified in 197. Now we are moving forward to section 2 of part 2 of schedule 5, which deals with remuneration payable by companies having no profit or inadequate profit, where in any financial year during the currency of tenure of managerial person, a company has no profits or its profit are inadequate, it may pay remuneration to the managerial person not exceeding the limits under A and B given below. Under A and B given below, where effective capital is negative, or less than 5 crore. Where effective capital is negative or less than 5 crore, the limit of yearly remuneration shall not exceed 60 lakh. The limit of yearly remuneration shall not exceed 60 lakh. Where the effective capital is 5 crores and above, but less than 100 crores. Limit of yearly remuneration shall not exceed 84 lakhs. Where effective capital 100 crores or above but less than 250 crores, limit of yearly remuneration shall not exceed 120 lakhs. Where effective capital is 250 crores or above limit of yearly remuneration shall be 120 lakh plus 0.01% of effective capital in excess of 250 crores. There is a proviso provided that remuneration in excess of the above limit may be paid if resolution passed by the shareholder is a special resolution. Explanation: it has been it is hereby clarified that for a period less than 1 year, the limit shall be prorated. In case of managerial personnel who is functioning in a professional capacity, remuneration as per item A may be paid if such managerial person is not having any interest in the capital of the company or its holding company uh, or any of its subsidiary, directly or indirectly or through any other statutory structures, and not having any direct or indirect interest or related to directors, promoters of the company or its holding company or any of its subsidiary at any time during the last 2 years, before or on or after the date of appointment, and possess graduate level qualification with expertise and specialized knowledge in the field in which the company operates. There is a proviso states that any employee of a company holding shares of a company not exceeding 0.5% of its paid up share capital under any scheme formulated for allotment of share to such employee, including employee stock option plan or by eye of qualification, shall be deemed to be a person not having any interest in the capital of the company. Provided further that the limit specified under item A or B of this section shall apply if the payment of remuneration is approved by the resolution passed by the board, and in case of company covered under subsection 1 of section 178, also by the nomination and remuneration committee. The company has not committed any default in payment of dues to any bank, public sector institution, non-convertible debenture holder, or any other secured creditors. In case of default, the prior approval of bank, public financial institution concerned, any non-convertible debenture holder, any or other secured creditor, as the case may be, shall be obtained. Prior approval of these parties will be shall be obtained by the company before obtaining the approval in general meeting. An ordinary resolution or special resolution, as the case may be, has been passed if the ordinary resolution or special resolution, as the case may be, has been passed for payment of remuneration as per item A, or special resolution has been passed for payment of remuneration as for item B at the general meeting of the company for a period not exceeding 3 years. If a statement along with notice calling the general meeting referred to in clause 3 is given to the shareholder containing following information. Containing what information? Containing, let's see, what information should be there? Containing general information, notice containing general information, nature of industry, expected date of commencement of commercial production in case of new companies, expected date of commencement of activities as per project approved by financial institution appearing in the prospectus, notice containing general information, financial performance based on given indicators, foreign investment or collaborations, if any, information about appointee, information about appointee, information about appointee, background details, past remuneration, recognition or rewards, job profile, his suitability, remuneration proposed, uh, comparative remuneration profile with respect to industry, size of the company, profile of the position and person in case of expatriates. The relevant details would be with respect to country of his origin, pecuniary relationship directly or indirectly with the company, and relationship with the managerial personnel, if any. Other reason, other information, other information, other information, a reason for loss or inadequate profit, steps to be taken or proposed to be taken for improvement, expected increase in the productivity or profits in measurable terms. And there are some disclosure to be made. Let's see what are the disclosures. Following disclosures shall be mentioned in the board of directors report under the heading corporate governance. If any, attached to the financial statement, all elements of remuneration package such as salary, benefit, bonuses, stock option, pension, etc. of all the directors, um, details of fixed component and performance linked incentive along with performance criteria, service contract, notice period and severance fees, stock option details, if any, whether the same has been issued at a discount as well as the period over which accrued and over which exercisable. Let's see, there is an explanation for the purpose of section 2 of this part. Statutory structure means any entity which is entitled to hold shares in any company formed wider any statute. Section 3 of Part 2 of Schedule 5, which deals with remuneration payable by company having no profit or inadequate profit in certain circumstances, which deals with Section 3 deals with remuneration payable by company having no profit or inadequate profit in certain circumstances. In the following circumstances, a company may pay remuneration to managerial personnel in excess of the amount specified in Section 2 above. What are the circumstances where the remuneration in excess of limit specified in section 1 section 2 is paid by any other person, where remuneration in excess of limit specified in section 1 section 2 is paid by any other company, and that other company is either a foreign company or has got the approval of its shareholder in general meeting to make such payment, and treats this amount as managerial remuneration for the purpose of section 197. The total managerial remuneration payable by such other company to its managerial persons, including such amount or amount, is within the permissible limit under section 197. Now let's see what is the second circumstance where the company is sick, newly incorporated company for a period of 7 years from the date of incorporation, where the company is a sick company for whom a scheme of revival or rehabilitation has been ordered by the board for industrial financial reconstruction for a period of 5 years from the date of sanction or scheme of revival. There are more other circumstances. Let's see what are they. Where the company is a company in relation to which resolution plan has been approved by the company law tribunal, company national company law tribunal under insolvency and bankruptcy code for a period of 5 years from the date of such approval. It may pay any remuneration to its managerial personnel. Where remuneration of a managerial person exceeds the limit in section 2, but remuneration has been fixed by the board for industrial and financial reconstruction or national company law tribunal, provided the limit under this section shall be applicable subject to the meeting of all conditions specified in section 2 and the following additional conditions. These are following additional conditions: except as provided in para A of this section, the managerial person is not receiving remuneration from any other company. And next additional condition, auditor, company secretary of the company, where the company has not appointed a secretary or secretary has not appointed a secretary. A secretary in full-time practice certifies that all secured creditors and the term lenders have stated in writing that they have no objection for appointment of managerial personnel, as well as the quantum of remuneration, and such certificate is filed along with the return as prescribed under subsection 4 of section 196. The next additional condition, auditor or company secretary, where the company has not appointed company secretary, a secretary in whole-time practice certifies that there is no default on payment to creditors and all dues to deposit holder are being settled on time. So these are the additional conditions to be fulfilled. Now we are moving forward to section 4. Perquisite not included in managerial remuneration. A managerial person shall not be eligible for the following perquisites, shall be eligible for the following perquisites, which shall not be included in the computation of selling on remuneration specified in section 2 and section 3. The contribution to provident fund, superannuation fund, annuity fund, to the extent these either singly or put together are not taxable under the Income Tax Act. Gratuity payable at a rate not exceeding half month's salary for each completed year of service. This is also not includable in the managerial remuneration. Encashment of leave at the end of the tenure. Second perquisite, which is not includable, in addition to the perquisite specified in para 1 of this section, expatriate managerial person, including a non-resident Indian, shall be eligible to the following perquisites, including a non-resident Indian shall be eligible to the following perquisites, which shall not be included in the computation of selling on the remuneration specified in section 2 and or section 3. Children education allowance in case of children studying in or outside India, and allowance limited to maximum 12,000 rupees per month per child, or actual expense incurred, whichever is less. Such allowance is admissible up to maximum of 2 children. Holiday passage for children studying outside India or family staying abroad. This is another perquisite. Return holiday passage once in a year by economy class or once in 2 years by first class to children and to members of the family from the place of their study or stay abroad to India if they are not residing in India with the managerial personnel. So children, member of the family and managerial personnel by economic class. The benefit is economic class, once in a year economic class, once in 2 years, in 2 years in first class. they can enjoy these benefits. Now let's see the other prerequisites. Leave travel concession, leave travel concession, return passage for self and family in accordance with the rule specified by the company, where it is proposed that the leave be spent in home country instead of anywhere in India. Leave travel concession, return passage for self and family in accordance with the rule specified by the company, where it is proposed that leave be spent in home country instead of anywhere in India. Explanation 1 for the purpose of section 2 and of this part. Effective capital. What is the effective capital? Effective capital means the aggregate of paid up share capital excluding share application money or advance against share amount, if any, for the timing standing to the credit of share premium amount, for the timing standing to the credit of premium account, that means share premium. Effective capital includes paid up share capital but excludes share application money, advance against share, but includes share premium, reserve and surplus excluding revenue revaluation reserve, long-term loans, deposits payable after 1 year, deposit payable repayable after 1 year excluding working capital loans, overdrafts, interest due on loans unless funded, bank guarantee, etc., and other long-term arrangements as reduced by the aggregate of any investment, as reduced by the aggregate of investment, except in case of investment by investment company whose principal business is the acquisition of shares, stock, debentures, or other securities. And accumulated loss reduced by the this amount. Effective capital will in calculation of effective capital, any investment excluding this as investment, acquisition of stock, share, debenture, other securities will be deducted. Any investment other than this investment, accumulated losses will be reduced and preliminary expense will be reduced for calculation of effective capital. Let's see explanation 2, where appointment of managerial person is made in the year in which the company has been incorporated. The effective capital shall be computed as on the date of such appointment. In any other cases, the effective capital shall be calculated as on the last day of the financial year preceding the financial year in which appointment of managerial personnel is made. Now let's see the next item. Next, see the explanation 3. Explanation 3, for the purpose of this schedule, family means spouse, dependent children, dependent parents of managerial personnel. Explanation 4, nomination and remuneration committee, while approving the remuneration under schedule 2 or section 2 or section 3, nomination and remuneration committee, while approving remuneration under section 2 or section 3, shall take into account financial position of the company, trend in the industry, appointees, qualification, experience, past performance, past remuneration, etc., and shall Remuneration committee shall be in the position to bring about objectivity in determining the remuneration package while striking a balance between the interest of the company and the shareholders. Explanation 5. For the purpose of this schedule, a negative effective capital means effective capital which is calculated in accordance with the provision contained in explanation 1 of this part is less than 0. Effective capital which is calculated in accordance with the provision of explanation 1 is less than 0. Explanation 6. For the purpose of this schedule, remuneration means remuneration as defined in clause 78 of section 2 and includes reimbursement of any direct taxes to managerial personnel. Section 5. Remuneration payable to a managerial person in two companies. Section 5. Now let's see what the section 5 prescribes. Let's see what the section 5 prescribes. Section 5 of part 2 of schedule 5 of Companies Act. Remuneration payable to managerial person in two companies. Remuneration payable to managerial personnel in two companies. Subject to provision of section 1 to 4, a managerial person shall draw remuneration from one or both companies provided that total remuneration drawn from companies does not exceed the higher maximum limit admissible from any one of the companies of which he is a managerial person. Subject to provision of section 1 to 4, a managerial person shall draw remuneration from one or more companies, provided the total remuneration drawn from a company does not exceed the higher maximum limit admissible from any one of the companies of which he is a manager. So that's all about managerial remuneration. Thank you for watching.